Hi, my name is Lauren Morrison, and today's topic that I will be discussing is the H1B non-immigrant visa. The H-1B visa is a specialty occupation visa for a U.S. employer to hire a professional to work in a specialty occupation, which means the duties of that position require a person that has at least a U.S. bachelor's degree to perform those duties. So that means that the duties are complex and they require a professional that has at least a U.S. bachelor's degree. Every year, there is a cap for these H-1B visas, which means there are only 85,000 visas that are available every year. 20,000 of those visas are set aside for foreign nationals that have obtained their master's degree from a U.S. university. And those people are actually quite fortunate because if they're not selected in that initial master's cap lottery, that you have another chance when they get put into the general pool of all the other applicants that do not have a master's degree from a U.S. university. So there's 85,000 visas, but there are more people every year that apply. So USCIS has a way of dealing with this, and it's the lottery in which the U.S. employer, and if the U.S. employer is working with an attorney, both U.S. employer and the attorney both have their own USCIS accounts, and they file what's known as an H-1B registration for the foreign national that the U.S. company seeks to hire. So it's very basic information about the company, very basic information about the foreign national, and that is done every March of every year, and it's for the following fiscal year. So in April, they can start processing these applications no matter what, if it's a master's degree or a bachelor's degree case, it doesn't matter. Everybody that is subject to the H-1B cap, everybody has the same start date, which is October 1st of the year, which starts the U.S. government's fiscal year. So it's interesting that the equivalent of a U.S. bachelor's degree has been determined that if someone does not have a formal education or does have some formal education but did not achieve a bachelor's degree, or their foreign degree is not considered to be the equivalent of a U.S. bachelor's degree, that education can be supplemented with professional work experience. So in an example, a person does not have any formal education, post-secondary education, that person can establish eligibility by documenting 12 years of professional work experience. And that 12 years of professional work experience will be evaluated by a professional evaluator. And that evaluator will say, okay, well, this person worked in this capacity and performed these job duties. And typically these job duties are performed with someone that has a bachelor's degree, and that evaluator will determine what the degree would be in, like business administration or finance. And those H-1B petitions for those type of cases include that evidence. They have the letters that are written by former employers and along with the evaluation, any foreign degrees and transcripts. So part of the process of the H-1B is to show eligibility, and that is to show how the individual does indeed qualify, whether it is a master's degree or a bachelor's degree from the United States, foreign degree that is considered to be the equivalent of a U.S. bachelor's degree or more, or a combination of both, or that professional work experience that's documented over 12 years, so that every 3 years of professional work experience equals 1 year of university study. So in the 85,000 visas are now, it's more of, I would call it like a rolling admission, where in years past, they would collect all of these H-1B visas applications. The petitions were sent on April 1st of every year, and there would be an influx of all of these applications. And immigration used to have to do the lottery with paper applications, and then any of the applications that were not selected would be returned to the employer with a blue paper that basically says that you were not selected this year. The way they do it now with this online account allows immigration to keep on doing this lottery and selecting people so that all visas are used and accounted for that fiscal year. If a person is successful in obtaining that H-1B visa, there's an approval from the Immigration Service. And if they're in the country in valid status on October 1st, they would change their status from whatever they are, typically an F1 student, maybe an OPT doing the post-completion work experience. And then they would change their status from F1 to H-1B on October 1st. One of the other qualifications on this H-1B is that the employer must show that the ability to pay this prevailing wage, which is determined by the Department of Labor to say a person that has the same job in Texas versus Florida versus New York versus California versus Idaho, while the job is the same, the pay scale is different just based on the geographic location. And the prevailing wage is the minimum payment that an H1B employer can pay the H1B beneficiary, the person working for them, in that position. So part of that process is filing a labor certification with the Department of Labor, which basically says, here's the company information, it's a code that is best described what the position is. And based on where they're located, what county and what state, there are 4 levels of prevailing wages. Level 1 is an entry-level position. Level 2 has a little more experience. Level 3, a little more experience than that, pretty much well on your way into your career. And level 4 is the top salary that would be offered for that position. So as long as the employer is paying that level 1 wage to the H1B employee, the labor condition application will be approved by the Department of Labor, and that labor condition, it's called an LCA, the labor condition application will be filed with the H1B petition to the U.S. Immigration Service. The initial validity period of an H1B is 3 years, and it can be renewed for another 3 years. So the total time that a person can spend in the United States in H1B status is 6 years. But any time that they have traveled abroad and outside of the United States during those 6 years, they can actually kind of recapture those dates that they were out. If it was 47 days, 87 days, whatever date it was, they can actually tack that on to the 6th year anniversary and extend their stay in H1B status to recapture those days that they were out during those 6 years. Another benefit to the H1B is if someone has a labor certification green card case that is pending, but their priority date has not yet come up. That allows the person, if they have filed the PERM application, which is the employment-based green card, if they have filed that prior to their last year in H1B status, the H1B visa can be extended beyond that 6th year, and as they wait for their priority date to become current, and then they can move from the H1B visa to a green card, legal permanent resident status. So the visa itself, if you get an approval notice from the Immigration Service, USCIS, and if you're here, like I said, you would change from one visa status to the next on October 1st. But if you are outside of the United States, you would need to apply for the H1B visa to be stamped into the passport, so that when the foreign national enters the United States, they will be in H1B status, which will allow them to work, get a social security number, etc. And because all of these new H1Bs begin on October 1st, the new foreign nationals with the visas typically are allowed to enter the United States 10 days in advance of the start date so that they could settle in and get prepared for their first day of work. The H1B visa has a dual intent, which means that while it is a non-immigrant visa, it also allows that foreign national to say that they will perhaps apply for a green card while they're in the United States. In contrast, a tourist visa or a student visa is an application where they say, I'm returning back to my home country. I'm just going for a visit, to visit some family. I'm going to attend university. But after my stay in the United States is over, I plan on coming home. And one of the reasons why those type of visas may be denied is that the consular officer that is looking at the visa application may not believe that they have an indication that their intent is to return to home. So those visas could be denied. Not true for the H1B visas. That dual intent means while it is a non-immigrant visa, it is also that dual intent of having that immigrant intent is okay. So the H1B visa, like I said, is about having a specialty occupation, and there are ways to determine that the H1B is the position that's being requested is a specialty occupation. And you have to satisfy one of these criteria, which is that the degree is normally the minimum entry requirement for that particular occupation, or the bachelor's degree is normally required to perform job duties in parallel positions among similar organizations in the employer's industry in the United States, or the employer or the third party, if the beneficiary will be staffed to that third party, normally requires a U.S. bachelor's degree or higher in a directly related specialty occupation and its equivalent to perform the job duties of the position. Or finally, the specific duties of the offered position are so special specialized, complex, and unique, that the knowledge required to perform them is normally associated with the attainment of a U.S. bachelor's degree or higher and a directly related specialty specific degree. So the degree that the person has must match what the specialty occupation is. When the H1B employee starts to work with an H1B employer, there is a file that must be kept, and it includes the LCA, the prevailing wage from the Department of Labor, and certain documents that there's an H1B file that is kept for this person. It is common for people in H1B status to go on for an employment-based green card. So a lot of the times the H1B employer is also the employer that is sponsoring a green card application. And the H1B is really desirable because it does have that dual intent. So certain countries, there are more denied visas because of that non-immigrant intent issue. So it is a highly sought after, highly coveted visa that's available once a year. So, every March there is a registration period where the lottery is performed online. And then after that, when the applications are selected for further processing, the petitions must be submitted within 90 days. And then if they're approved, that October 1st start date would be the first day that they're eligible to come into work in the United States in H1B status.